Welcome to the definitive guide of buyer agent compensation in California. Hi, my name is John McConnin. I'm a real estate attorney and a broker, and I'm just going to start out in saying that California Civil Code 2079.19 and the Civil Code governs this, not NAR. Those are NAR rules, not CAR. Those are California Association of Realtor rules, not the MLS. Those are MLS rules. I've seen this mistake over and over on the internet by real estate agents and people advising them. And just because they have new issues pushed upon them by class action lawyers and their settlements, and the DOJ chiming in ways, does not mean that the DOJ is right, the class action lawyers are right. I mean, this is California law. California law is right for California, okay? And until it changes, this is the law. A listing agent and selling agent may agree to share any compensation or commission paid or any right to any compensation or commission for which an obligation arises as a result of a real estate transaction, and the terms of any such agreement shall not necessarily be determinative of a particular relationship. I looked far and wide to see if it was changed in 2024. I came across nothing that said it was changed for 2024. I no longer have a subscription to Westlaw because I don't litigate, but as of 2023 and my internet searches, I saw no changes to that. And it makes sense, right? Why would it change? If somehow CAR or people lobbied to change those rules, there'd be no point for even having a listing agent, because a FSBO would just say, I want to compensate agents to bring buyers to my property, so I'll tell any agent who brings a buyer they can have 3% for selling my home. So, I mean, that can't change. Otherwise, there'd be no point of having a real estate agent, in my opinion. I mean, I'm sure people could come up with ridiculous ways, but it just wouldn't make sense to change that. So now, just because CAR and NAR have problems doesn't mean a licensed real estate agent in California has a problem doing it. They just have to do it right, with the right things to consider. So let's go over that. Let's go over the fact that, first of all, because the listing agreement no longer has any forms or any lines for buyer agent compensation in it, and the only thing is that the MLSA, if you were going to attach it, you'd say, well, would you like to consider concessions on the MLS? I suspect you could always say no, but why not say we'll consider concessions? So that will be sort of notice to everyone that buyers and listing agents, when they read that, hey, my seller is not just using the MLS to find buyers to come to the property, but we're using the MLS because we want to work with people who are offering concessions to buyers, which then can be interpreted by agents as saying they're open to negotiating buyer agent commissions. And as long as that's a little signal there, that's like a code, buyer's agents will probably be willing to work, send over offers, and request compensation. Now, as the listing agent goes in, and I would advise every listing agent to not discuss specific amounts. You just say, right now, because I want to pay attention to DOJ concerns, and I don't want to get you in hot water or myself in hot water. I mean, you can run your listing appointment, but the point is today, and for at least 24 hours till I put this listing up in the MLS, we should not consider amounts or levels of buyer agent compensation, and we can discuss that as soon as you want afterwards. However, I've got an attorney on our team, and he thinks we should see how we do for the first 7 days, and then if we wanted to start discussing making unilateral offers of compensation, we can. But for now, let's just deal with it as the offers come in. You can deal with it at a case-by-case basis, and we'll just say we're open to concessions. Most sellers are going to like that. They might save 2 or 3% in fees. So I think that works really well. Now, let's talk about the class action concerns first. This was, we can put it down as sort of like commission fixing, collusion, saying we're going to go in and pre-negotiate the buyer agent commission, so hopefully we can keep the prices up and make lots more money. So that's gone with this listing agreement and the format I just discussed, in which you don't agree to any particular levels of compensation, and you can say it can always be zero. It can be, it's up to you. It's negotiable, and there's no form. There's no. It's not on the RLA. There's no California Association of Realtor forms that discuss unilateral offers of compensation or broadcasting them. So I think we've gone a long way to eliminating this price fixing concern. Now, one of the other concerns in some of these cases was that sellers don't want to pay an agent to negotiate against them. You're paying an agent to try to lower your price. They don't like that. That was brought up in some of those class action suits. Again, that's why I highly state, do not talk about amounts and say it's up to the seller. And then if they're not getting the offers they want, if they are not getting as many offers as they want, then you can talk to them about broadcasting offers of compensation. So now the DOJ concerns. I will have a very strong video on steering and the DOJ's concerns. The DOJ, when I read the no-select case, and from what I've read and heard the CAR president say, no, the NAR, National Association of Realtors, say, is that they want to decouple commissions, listing agent and homeowner discuss the listing agent's fees, buyer agent and buyer discuss the buyer agent fees. That's been accomplished by these changes in forms and these new rules, in my opinion, quite significantly and successfully. But even, I think I've even seen the DOJ say, but we understand that there may be requests by buyers to pay their agent compensation. So, like, we already know that buyer agent compensation is not against the rules. It just has to be done properly. So, next, we know that they made, it's kind of snarky, but legit. And they said something about, and I've covered this in a video on the no-select case. And buyers will be happy to know that their agent wasn't incentivized to have them pay more for the property. Because obviously, if an agent's getting 2 or 3% and they have their buyer pay $100,000 more, that's $2,000 or $3,000. So I think one of the ways to mitigate against that is offer flat fees rather than percentage-based fees. They could be in the general ballpark, but make them flat. So if it's $1 million and you're thinking about offering 2%, offer $20,000. And if it goes, and if the final price is only $1.9, well, the buyer agent's still going to get $20,000. Or offer 19 to start to leave that flexibility for you. But I'd say offer flat fees over percentages. That gets rid of one of those concerns to a large extent, in my legal opinion. Now, finally, steering. This one's a bit trickier, but let's consider all the factors that are involved now. Right now, the buyer's agents and the buyer are going to be talking about how much the buyer agent's going to be paid ahead of time. Now, some buyer agents are going to say, hey, if there's no offers here, you're working with me and you're going to owe me $20,000 if we buy a home, or $5,000 or whatever they've agreed to. Of course, already, because of the DOJ's concerns and these class action lawyers, they've made this more steering. There's going to be more steering going on ahead of time than less. There's going to be more shenanigans possible than fewer. I mean, right now, if sellers can determine who they want to make offers of compensation to and how much they are, not on a unilateral basis, but on an ad hoc customized basis, all these other concerns, like what if a seller's like, my neighbors are really going to like this buyer more than that buyer, so let's agree to pay that person's agent $2,000 or $20,000, and let's only offer $500 to that person's agent. Like this is crazy, considering, and I'll do a longer framework, and you're all going to want these arguments in the future. If the DOJ is bringing up steering concerns, then why did they set up buyer agents and buyers so that if a buyer agent's going to get paid, they may have to only go to properties where 2% is being offered, because otherwise the buyer's going to come out of pocket for the money, and some buyers aren't going to have that money, especially if they wind up negotiating higher prices. So none of this process is eliminating steering concerns. So my point is, let's do unilateral offers of compensation properly, because I think they actually can eliminate more of the DOJ's concerns than less, and we've already gotten out of the price fixing thing. So I think we'll be all right. But I can't eliminate it, but I can just say, if we examine all the issues and we make our buyers sophisticated and we put buyers attorneys on the buyer team to discuss these very issues with the buyer agent, with the buyers, I think we're good. Like, I think that putting an attorney on the buyer's team should eliminate all the lawyers at the DOJ's who have concerns, because now the buyers are going to be protected. They can understand that steering could have come about and that maybe they didn't see these other properties, but it was done for financial reasons because the buyer wanted compensation for their agent so they could get the help of an agent. Like, boom, we're going to eliminate DOJ concerns by getting educated buyers with a lawyer on their team, period. Now, I know that's killing agents, but hey, if you're offering $20,000 in compensation, you just say, hey, let's set aside $1,000 of it, so we'll offer $19,000 and give $1,000 on the HUD to a buyer attorney, and we'll make sure that the buyer agent, I'm going to prepare all the forms and make them available, the buyers are going to sign off on all these forms so that and eventually they're going to say, and they talk to an attorney. So I think we're going to get away from DOJ concerns. So now let's just summarize. We've seen that it's legal in California. We're going to mitigate against the risks. Now, before you just take my form and say, hey, you want to offer 2%, I think you're going to want to have educated clients. We're going to cover that in other videos. But now I want to go over just bootstraps and suspenders. I'm going to go over some of the things Carr and NAR said, just so you feel better about what I was explaining. Now, I summarized the facts and made them big here. And this was from, and there's still, this was clear in March 22nd, but the recent NAR settlement facts still say many of the same things. So let's just cover this. Is it possible for offers of compensation to be conveyed through channels other than the MLS? Yes. Offers of compensation could continue to be an option consumers can pursue off MLS through negotiation and consultation with real estate professionals. This is, as I've said in other videos, especially during the short sale days, this was Carr's code or NAR's code. It was when Carr was using this for lawyer. I mean, this is real estate professionals. Well, you know, if an agent needs to consult with a real estate professional, who's that going to be? If a seller's already got a listing agent and they need to consult with a real estate professional, who's that's going to be? It's going to be an attorney, and I'm going to tell you why. Because there's no forms in the Carr forms for this. They're saying these forms have to come about, they have to be generated outside. Realtors are not licensed to generate forms. It has to be real estate attorneys. So, in consultation with real estate attorneys, you may offer compensation and they can be conveyed through channels other than the MLS. And sellers can offer buyer compensation on the MLS, for example, concessions for buyer closing costs. And this is a little more overt. I think they've toned that down since, but that was I wish I hadn't just done that. Let me see if I can edit and undo. It doesn't matter. This is my document. And I cut and paste it. Now, is it possible offers of compensation? Yes, offers of compensation continue in ML, and a seller can offer buyer concession in the MLS. So I duplicated it. Or no, they duplicated it because it was in 6 and then it was in 19. Here, I'll show you the form. It was this form. And let's just see that I got it right. 6. Is it possible for offer compensation? Yes. For example, yes, offers of compensation could continue to be an option consumers can pursue off MLS through negotiation and consultation with real estate professionals, and sellers can offer buyer compensation on an MLS. For example, yeah, that's exactly. And now I think they've toned that down with respect to making offers of concessions. The concessions have to be, they're just a yes, no now on the CRMLS. 19, is it possible offers of compensation to be conveyed through channels other than the MLS? Yes. So they did duplicate it. And that's why I cut and pasted twice. I was going through it, cutting and pasting the ones I found most appropriate. 23, how will offers of compensation be communicated if brokers can't use MLSs? Doesn't this just make broker compensation less transparent? Offers of compensation, that was the question. Offers of compensation could continue to be an option consumers can pursue off MLS through negotiation and consultation with real estate professionals, just like above. And sellers can offer, yes, that's the exact same thing. It's a repeat. The settlement does not change the ethical duties of NAR members owed to their clients. NAR members will continue to use their skill of care. So I believe those duties include making sure your clients are well advised with an attorney if they're going to take the risks of offering compensation to buyer's agents. And I have a program. It's going to be super affordable that will be discussed when you download the form that will be available at winnerscheck.com. Now, are independent MLSs affected by the prohibition publishing? Independent MLSs are not required to prevent offers of compensation in MLS. So that's how you really know it's a NAR and Carr issue. It's not even a change in the rules. Independent MLSs are not controlled by this Carr settlement and the law. They didn't say anything illegal. Can a buyer request a listing broker compensation? Offers of compensation continue to be an option. I guess they keep repeating the same thing throughout that document. Okay, which is fine. Once, obviously they're very happy with their wording. Now, this was the more recent settlement fact. What if, and I don't feel like pulling up. I'll just read from it. You can find a more recent settlement fact. I think this is the most current one. What if a seller decides to advertise compensation on social media? CRMLS does not regulate social media. As a reminder, Carr listing forms do not support sharing compensation. And if a different non-Carr form is used, then it's important that form is designed to support this type of advertising. In other words, make sure an attorney who knows what they're doing, a real estate attorney, probably familiar with this. I mean, yeah, like I'd say a broker attorney who's been doing this for a long time is going to understand the issues. And I happen to be one of those people. Go to winnerscheck.com, download the form, see the further training and the offer that I'll make to help you educate your clients on a, my goal is one-to-many, like in the marketing terms. We're going to go one-to-many with videos. I'm going to have an AI ask a few questions to see what training they need further. And we're going to try to do this in 5 or 10 minutes worth of training. And then we'll give them a right to talk to me. They'd have to pay for that, but they can turn it down and then go back and say they're a certified seller. And then they'll have the form that they'll handwrite in and say, I understand the risks and I'd like to offer this amount. And we're going to broadcast offers, unilateral broadcast of, I'm authorizing you to make unilateral offers of compensation and broadcast them in the appropriate places. And we'll discuss that too. This I thought was very interesting. That's why I included here. Can compensation be advertised on for sale signs? According to Carr, yes. But a picture of the sign cannot be loaded into the MLS. As a reminder, Carr forms do not support sharing compensation. So this can only be done. Like, to me, this is the ultimate statement. I probably should have led with this, and I will do that in a short. Right here, Carr's saying it's illegal because you're broadcasting it on a MLS sign. People are going to be on a sign. People are driving around the neighborhood. Buyer agent compensation is being offered, but they're saying you got to do it the right way. And I'm telling you, please trust me on this. The right way is with seller education, because there are risks, explaining to them how we're going to mitigate those risks, but some of them are still not absolute. The risk that DOJ is going to go after them directly, minuscule. But as an agent, you're going to want to do this the right way, so the risks to you and your brokerage are minuscule. So you're going to say, I'm doing it the right way because my sellers were advised by an attorney and the buyers have an attorney. I'm telling you, like, I saw a lot of dire. I talked to a few agents over the last weekend. A lot of them were depressed. Some of it's dire. I thought that there's a real estate trainer guy out of Arizona today. He said, it's not over. His point was, it's not over. We're still going to be under heavy scrutiny. There's still class action suits by buyers. They're not over. So we have to do this the right way. So I'm telling you, if you want to keep this industry alive for you, the agents, I'm not worried about as a lawyer. If you're not willing to do it the right way, you're going to be gone and you're going to leave it to FSBOs and attorneys. I'm not the least bit worried about it as an attorney. The broker side of me says, wow, we got to worry about agents compromising the MLS. We worry about NAR compromising listing agents and the MLS. We've got a lot of things to worry about as a real estate industry. I'm going to be talking about that more. I'm not the least bit worried. The more agents don't do this properly, the more they try to get around this stuff, the more they're going to get hammered by the DOJ, and the more it's going to be wide open season, full employment for lawyers. I'm saying this. I know some of you are hating it, but I'm telling you, you've got to do it the right way or you're going to be gone, because all those forms for years have been designed to help you practice law without a license. And now the issues are coming home to roost. And the final thing is, we know lawyers are hated by jury pools. So, and judges. I know from personal experience, judges don't think much of real estate agents. Now, here's one other rule. I'm going to wind this up because it was getting longer. There's a rule. First of all, if I'm doing any of this stuff, I'm going to read those new rules about the fines. You want to make sure you are not doing things that are going to engender fines from your MLS. And the fines are really big, in my opinion. So you want to make sure all of this is beautifully disclosed to your sellers and they're well informed. Any excuses that you do this wrong, they've got these new big, massive fines on the MLS when you're doing things wrong. So don't try to get cute on the MLS and with sneaky offers of compensation. And don't do it wrong, and make sure your seller's well aware. Now, there's more we can get over. I think we covered it well. Go to winnerscheck.com. I'm drafting the form this weekend. We're going to be using it in our brokerage. I'm going to make a copy of it available to you. You're going to have to sign off and say you understand that it's just a draft, but it's going to be there. And I'm going to put in further training. As I'm drafting that form, I'm going to put in training that I'm as if I'm explaining it to the seller, so it's going to be there for you. And then there'll be further offers if you want to work with me in what I think is the one-to-many concept. So thank you. Talk to you later. Bye. John McConnin, real estate attorney and broker in California, winnerscheck.com.